termination from service matters, top 15 leading judgments of Supreme Court in 20 minutes. See now. I will give this judgment in brief facts, decision, ratio, decidendi, and citations also. So when there is unfair inquiry, unfair trial, dismissal unfairly, so that dismissal will be quashed by the apex court, by High Court, then by apex court, if High Court is not interfering. So these are such type of judgment, 15 judgments are there, which is helpful to the employees who had lost their job due to unnecessary harassment, due to unnecessary procedure not followed proper procedure for impeachment, not followed by rules by the employer, and they are terminating employees without any reason, without proper giving show cause notice, without proper giving chance to reply, chance to fair trial, like that. So first case, Shrikant K. Sinha versus State of Bihar, 1999. Facts: the petitioner was dismissed from service without proper inquiry. Decision: the dismissal was set aside. Ratio decidendi: fundamental principles of natural justice must be followed in disciplinary proceedings. And citation of this case is AIR 1999 SC 2086. 2. Indian Oil Corporation Limited versus Amritsar Gas Service 2009. Facts: the termination of gas agency was challenged as arbitrary. Decision: the termination was upheld due to non-compliance with the terms. Ratio decidendi: contracts must be executed in good faith adhering to the agreed terms. Citation: 2009 13 SCC 751. Case number 3, KK Verma versus Union of India, 1954. Facts: employee was dismissed without being given an opportunity to present his case. Decision: Supreme Court quashed the dismissal. Ratio decidendi: a government servant has a right to be heard before termination. Citation: AIR 1954 SC 321. Case number 4, KC Gupta versus State of Uttar Pradesh, 1980. Facts: the appellant was dismissed for alleged misconduct without proper inquiry. Decision: dismissal was declared invalid. Ratio decidendi: an inquiry is mandatory before termination to ensure fairness. Citation: 1981 SCC 220. RP Kapoor versus Union of India. Pooja. Facts: employee was dismissed under Rule 14 of the CCA rules. Decision: the dismissal was held to be unjust and set aside. Ratio decidendi: proper procedure must be followed in disciplinary matters. Citation: AIR 1964 SC 787. BC Chaturvedi versus Union of India, 1955. This is case number 6. Facts: the respondent was dismissed without an adequate inquiry. Decision: the court quashed the termination order. Ratio decidendi: disciplinary action must comply with the principle of natural justice. Citation: 1995 6 SCC 749. Case number 7, D.K. Yadav versus JMA Industries, 1993. Facts: laborer must terminated without due process. Laborer was terminated without due process. Decision: termination was void. Void means illegal. Ratio decidendi, principle of audi alterum pattern must be observed. Audi alterum pattern means, this is a Latin term, it means respondent must get the opportunity to give his statement, to explain his side, to give his remarks. So nobody can be terminated without operating due trial, without operating procedure established by law, proper law. Citation of this D.K. Yadav case, 1993, 3 SCC 259. Case number 8, V.K. Khanna versus Union of India, 2001. Facts: employee was dismissed after an inquiry where no evidence was presented. Decision: the dismissal was revoked. Ratio decidendi, evidence must be presented in a disciplinary hearing. Citation: 2001 to SCC 330. Only allegation is not sufficient, friends. Employer should not put only allegations. Allegations should be with proper proofs. So without proof, without evidence, evidence must be presented in a disciplinary hearing. Without evidence, no case can be entertained. Case number 9, Union of India versus Muhammad Ramjan Khan, 1991. Facts: dismissal of government servant for corruption without proper inquiry. Decision: the termination was quashed. Termination was terminated, quashed. Ratio decidendi, the burden of proof lies on the employer. Citation: 1991, 1 SCC 588. Case number 10, State of UP versus Raja Ram Jaiswal, 1985. Facts: government employee was removed from the service on charges of misconduct. Decision: held unconstitutional, removed without adequate inquiry. Inquiry should be adequate. Ratio decidendi, fair procedure is essential in a punitive action. Citation: AIR 1985 SC 945. Case number 11, Nirmal Chandra Bansal versus Registrar, High Court of Delhi, 2007. Facts: dismissal on the ground of inefficiency during the probation. Decision: the court upheld that inadequacy of service should be assessed with some parameters. Ratio decidendi, probationer should be assessed fairly against prescribed criteria. Citation: 2007, 12 SCC 537. 12, Chairman Railway Board versus Chandrima Das, 2000. Facts: bereaved family challenged appointment and payment for post dismissal without inquiry. Decision: the appointment was upheld, focusing solely on employment rights. Ratio decidendi, employment matters concern not just the individual but also family rights. Citation: 2002 SCC 465. Not 2002, 2000, then 2 SCC 465, like that. Case number 13, Tribal Cooperative Marketing Development Federation of India versus State of Madhya Pradesh, 2005. Facts: termination of the employees was questioned in High Court and reached Supreme Court. Decision: the termination order was found valid. This case was against employee. Termination order was found valid. Ratio decidendi: service terms are to be upheld if procedure are followed. Citation 2005 5 SCC 77. Case number 14, Suresh Chandra versus State of Uttar Pradesh, 2004. Facts: the employee was terminated for alleged misconduct without proper inquiry. Decision: the termination was quashed. Ratio decidendi: an inquiry must precede punishment constituting a breach of natural justice. Citation 2004 3 SCC 570. And last case of our today's episode is Bhagat Ram versus State of Haryana, 1989. Petitioner was dismissed for misconduct without proper procedure. Decision: the dismissal was declared illegal. Ratio decidendi: proper procedural safeguard must be observed, otherwise the termination is invalid. Citation 1989 1 SCC 372. And recently also in my two cases, termination was declared illegal by the apex court, friends. So from these 15 cases, only one case is against the employee. All remaining 14 cases are in favor of employee when termination is illegal. Now, friends, I will give you some Service Matters Acts, service laws. There are so many service laws. So every bank have a separate service rules, separate service rules. So every state have separate service laws. But it may be more than, I think, 200, 300, maybe more than 300 also, including all, including government, semi-government, schools, all. But some important central service laws and regulation I will present first. So first and most important service law and regulation, one, Constitution of India. In the Constitution of India, articles related to the service of union and state services. So in this part, you will get some service guidelines. Second, the All India Services Act 1951 governs the rules and conditions of service for all India services, Indian Administrative Services, Indian Police Services, and Indian Foreign Services. For these people, these service rules are there. Service Act is there. Rule, I will explain you later. 3. The Central Civil Services Classification, Control and Appeal Rules. This is rule 1965. The Central Civil Services Classification, Control and Appeal Rules 1965 govern the classification of civil services and the procedure for disciplinary action. 4. The Central Civil Services Pension Rules 1972 framework for pension and retirement benefit for central government employees. 5. The Central Civil Services Leave Rules 1972 rules governing various types of leave for central government employees. 6. Central government employees service conditions rules. Various rules pertaining to service conditions including pay scale and allowances. 7. The fundamental rule and supplementary rules provides service conditions like pay, allowances, and leave of government employees. 8. The Public Servant Inquiries Act 1850. It is a pre-independence. Public Servant Inquiries Act 1850. Regulate disciplinary inquiries against public servants. 9. The Right to Information Act 2005. Provide the right to access information held by public authorities. And 10. The Whistleblowers Protection Act 2014 encourages disclosure of information relating to the corruption to misuse of power. Many times it happens who is a non-corrupted, honest employee, and he is suppose blowing whistle against corrupted employees. So they are creating one trap and they are terminating that particular employee from that particular job. So this act will be applicable there. Whistleblowers Protection Act 2014. Now I will explain you some state service laws and regulations. State Civil Services Acts. Every state have authority to pass these laws, okay, according to the guidelines of central government. But state legislature will pass this law in a state assembly. Each state has its own act governing the recruitment, service, and condition for the state civil services. Second, state civil services rules. Specific rules for various categories of employees in state services, which may be similar to central rules. 3. State leave rules. Rules governing various types of leave for state government employees. 4. State pension rules. States have their own pension rules governing the retirement benefit of the state employees. 5. The State Service Commission's regulations, rules that govern the functions of state public service commissions. 6. The conduct rule, state specific, govern the conduct of the state government officials and employees. 7. Disciplinary procedure, state specific. States have their own procedure for dealing with the disciplinary matters, which are often outlined in their service rules. 8. State Right to Information Acts. Each state often has its own RTI Act governing access to information. While the above list outlines some of the primary service laws and regulations at the central and state level in India, there are many specific service rules and regulations that may apply depending on the department, organization, or position. Each state may have variations and additional laws specific to their governance. It's also important to refer to specific state government websites or publications for the latest updates and detailed regulation. Friends, in a near future, within a 1 month time, I'm recording one big video, and I will put on as a course in very reasonable price 48 corporate laws. 48 corporate laws. I will give the key features of each corporate law and with their rules and regulations. So it will take near about half hour, like that, 4 to 5 sessions. So that course will be available on my app, and the description of my app, everything will be in the YouTube video. You will get that, and you can ask to my PA also. My PA's number is in your message also, and on YouTube each video's description, my PA's number is there. You can ask to PS also. So she will provide you all my export-import courses and all my legal courses. So many legal courses are there, like SLP drafting, argument, like that. So many courses are there. How to increase legal vocabulary, then property matters SLP, then service matters SLP, then how you can guide to any client after getting the High Court order. Suppose you are practicing in Supreme Court, you are challenging High Court order. So after getting High Court order, how you guide the client, then you take that case, then how you draft that case, and everything is covered in that course with proper my own argued cases. Not a single course contain any fabricated case. All are my original cases which I prepared. I means not I, my team is there. My 13 juniors, my 13 associates are there, including 5 AOR are working with me. So all are our original, and we will provide that to you. So these are courses. And recently, when I completed my 60 years of my age and start now 61, then I drastically reduces all my courses fees. So if you go on app, you can find so many courses, and you can see all the contents matters like that. And if you are interested, you can join, and lifetime access to all the videos are there. Okay. So just hold on for some minute. I will unmute yourself, unmute you all. Then you can unmute yourself. Yes. Now you can unmute yourself and you can ask your question if you have any query in Hindi or in English language, or in Marathi also. I am Marathi, so I can speak in Marathi also. But it is better for understanding all India people, English or Hindi. Have you any difficulty? Any of you? Okay. Thank you. Thank you very much. Thank you very much for peaceful listening.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और Flipkart पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।